Thanks very much for joining us. We're going to be talking today about protecting intellectual property and how to integrate that into enterprise risk management. I'm Craig Moss, Chief Operating Officer at Create, and with me we have Alan Dixon, our Intellectual Property Counsel. As we get started here, let me give you a little bit of background on Create and our organization. We are a non-governmental organization founded in October of 2011 and received financial support from Microsoft to get started. And I do want to say, although our financial support originally came from Microsoft, we are looking at the broad set of IP issues as we'll go into. We're not focused at all on software piracy or copyright infringement, so we really look at it on a much broader base. Our mission is to help improve intellectual property protection and anti-corruption in global supply chains. And we see that as a critical issue. We look at IP and anti-corruption as separate issues, but that share some common features in terms of how they need to be embedded in how companies operate and how those in their supply chains operate. To achieve this mission, we've developed some services, create leading practices for IP protection and for anti-corruption. And all of the services that we've developed are already available in Chinese, English, Portuguese, and Spanish.
Well, I think the problem of intellectual property risks is one that is increasingly turning up at the boardroom and in the C-suite of companies all around the world. I mean, if you think about things like what the intangible value of companies is at the moment. As much as 75%, for example, of the Fortune 500 companies' value on their balance sheet is reflected in intangible assets like intellectual property. So when Craig and I talk to a lot of different companies and groups, and for example, you can see some statistics here, but among risk managers, now more than half are saying that intellectual property-related risks, loss or theft, had hurt their company's financial performance, and in 14% they say this has been major damage. So this is an issue that's really hot. It's really getting companies' attention. And if you talk to risk managers, for example, PricewaterhouseCoopers did a survey of risk managers last year, and intellectual property risk ranked in the top 3 risks of the manufacturing and technology companies that they surveyed in their report. So really, IP risks across the board are seen to be increasing, and the question really is, what can we do beyond just being reactive? If something gets stolen from our company, or if we have a counterfeiting or a trade secrets problem, we're good at reacting usually, but is there something? Are there things we can be doing to help manage this better over time to just reduce the risk that this kind of activity will happen? Those of you on the phone that deal with intellectual property in your business or have had any contact with it will know that there's serious financial and reputational risks that can come with IP problems. This is not just the negative side of the story. I mean, we're talking about preserving the value of your companies and preserving the reputation of your companies in the market, which is part of maximizing shareholder value, of course. But you think about patent and copyright infringement, counterfeiting kinds of problems. That goes to the bottom line as lost sales, and depending on what the problem is, there can be a lot of legal fees and costs associated with that. Trade secrets theft, which we'll talk about quite a bit today, is a huge concern for many companies, and that is really one that goes to the heart of a company's competitiveness. If your secret sauce, if your secret ways of doing things, if your secret information is the basis on which you successfully compete against other companies, if that information goes out the door, the value of your company can be substantially hurt. And so there's all kinds of as we say, sort of financial risks, legal proceedings. There can be supply chain interruptions from IP-related problems. As we said, reputational harm from if your company ends up having a problem with IP.
Alan, one of the things related to trade secret theft that's really interesting is that with the globalization of manufacturing, a lot of companies are sharing trade secrets with contract manufacturers. And we see that as increasingly as an area that's problematic. If I teach a company how to make something, I'm sharing my process know-how with them. And that is something that really is creating a lot of problems for companies. And it's something where they do need to put more focus on how to effectively reduce that risk.
Well, exactly. And you look at some of the cases that have made headlines in the last couple of years. I mean, there's an American wind turbine company who shared its trade secrets with a customer that was going to do some manufacturing and incorporating their technology into their wind turbines. And two of the employees that left and apparently shared that information with the customer, the secret sauce, resulted in what the company is claiming in litigation are $800 million of loss in sales and 500 jobs as a result. So this is real dollars and cents, pounds and pence, as we say here in the UK, issues for companies.
Yeah, it really is an issue. And I was talking with a company recently at a conference, and they said that in their case, and they feel in many cases, the monetization of patents often occurs through the use of trade secrets. And that there's a link there between, when somebody's, again, monetizing or using those patents in the marketplace, the trade secrets are often involved. And that was kind of a different take on it that I hadn't really thought about before.
Yeah, it's very much an increasing place where a company's intangible value sits is in trade secrets, absolutely.
So tying this back and starting to think about risk assessment and risk management, today if we look at the supply chain, and whether we're looking upstream at suppliers or downstream at distributors or business partners, most companies do some kind of risk assessment in the supply chain, and typically they look at financial stability of the third party. Of course, they're looking at quality control or the capability to deliver on the service being contracted. Upstream in particular, they're looking at health and safety, environment, and labor. And the environment and labor has really grown over the last probably 10 or 15 years as a more and more important part of assessing risk. But what we're starting to see now, and what we very much encourage, is to make that even more holistic. As you start to evaluate those third parties, start to think about what is their ability to protect your intellectual property. What is their ability to provide security around your trade secrets? And, of course, other type of compliance issues. But today we're really going to focus on the IP protection piece. And we are starting to see multinationals that are heading in this direction toward a more holistic approach as they're evaluating those third parties.
I mean, I think the Roche pharmaceutical company is a great example. I mean, they have all kinds of risks that they deal with their supply chain already, and have put together a team internally to look at things like safety, security, environmental issues, partnerships with other firms, procurement. So the people internally that deal with all of these things, collaborate and work together on risk assessment and risk management. And then they, as a group, not just sort of one at a time and reinventing the wheel, but as a group they look at social issues, for example, labor, human rights issues, privacy issues in a holistic way, Craig, as you were saying. Environmental issues are part of their remit. And then economic risks, bribery, business interruption, theft, things like that. And also in that bucket, they include counterfeiting IP risks. Mm-hmm. And so when they do risk assessment on their critical suppliers, one of the important things they look at is the potential loss of IP in various ways in the supply chain with these suppliers. So very much a holistic approach, and looking at the things that companies traditionally have looked at under risk management, but including IP as a natural extension to that.
And in next week I'll be visiting with some companies in Hong Kong and in China, and they've already brought this up as a trend or a direction that they need to go. Is how do they they spend a lot of time and money evaluating third parties. How do they add, in a cost-effective way, how do you add IP protection to the mix of what they're already doing to evaluate third parties? And it makes perfect sense, that it needs to be done. Because, again, you're contracting a third party to make your good. They're using your trademarks. They might be using your copyrighted products, using your trade secrets. How are you assured that they're protecting that? And then flip that around. And if you are the supplier to a multinational or a potential supplier, in the old days, if you had a good quality management system, you had a competitive advantage. But that's not true anymore. I mean, now all of these companies around the world have good quality management systems, or they're not even in the game. Increasingly, they're putting in decent health and safety, environmental management programs, making headroads on the labor side. But now these suppliers are starting to realize that they can gain a new competitive advantage by having a better IP protection program.
Well, Create.org has just very recently released a new white paper on this whole issue of protecting intellectual property through ERM. And if you haven't seen it, it's sort of featured on the front page of our Create.org website. And I think you'd really find it interesting to download and have a look at. But basically, we have put together some practical guidance, some case studies of the types we're going to be talking about today, some templates and checklists which we'll be showing you of what kinds of things to look for, how to sort of get your arms around the IP and the risks that you need to manage, and then use these with not just a one-of-a-kind burst of energy, but over time with your business processes that measure, improve, that continue to monitor and work on these kind of risk management over time. So we're going to be basing quite a bit of what we're going to be talking about for the rest of the webinar on what's in the report. But I would recommend this to you because it's got quite a bit of useful information that we haven't seen put together in one place so far. So
let's take a step back, and I'm not sure of the audience if we have people that are risk management professionals or lawyers or supply chain or sourcing people, but taking a real quick look at enterprise risk management, there's typically three big steps to it. So identify the risk. What is the risk that we face? And of course now we're thinking specifically about the IP risk. Assess that risk. And really, how serious is it? And along with that, I always tend to think about risks in terms of the likelihood or probability of it taking place, and then the severity of the negative impact. So if you think about trade secrets again, obviously the most famous one is probably the Coca-Cola formula. The negative impact of that being publicly available would be enormous to the company. Enormous. So although the probability is very low based on the protections they have in place, the severity is extreme. So as you think through risks of IP protection, that's really the part, is you need to start to assess that, and we'll talk about that in a minute. And then after that, what do you do? We have risk. What do we do to mitigate the risk or to try to at least reduce the impact if it did happen?
There are a few different, let's say, standards or kind of systems of risk management that we summarize in the paper and refer you to. Some very formal standards set out by COSO, for example. ISO has a standard in the works, and there are others. But what we're going to do here is really look at the types of things that one does in a typical enterprise risk management program and talk about how those can be applied to the intellectual property protections and risks that you want to do as a company as well. So the first step is really identifying the risk, and that in the IP area, well, in every area really, looks at a couple of things. One is establishing the context for those risks, and that is things like, what are your business objectives, what's important to your company, in the IP area, what particular IP is important to you, how does this fit in with your overall business. Looking at things like your organization, where does IP get looked at in your organization, supply chain, does supply chain touch your intellectual property, or do they manage other intellectual property in ways that can affect your own company? And then the context also includes things like your own company's risk tolerance, and that varies obviously from company to company. And then in identifying risks, there's probably a few different ways of looking at the types of risk that you may deal with, but these can be generally summarized as strategic risks, operational risks, compliance risks, financial risks, and reputational risks. And those are fairly obvious, I would say, but strategic risks are really, bet the company kind of risks, things that go to your overall mission and your objectives. Operational risks come up in the day-to-day running of your business, and compliance risk obviously have to do with government regulation, legal requirements, or standards or industry practices that you've committed to, or even contractual commitments that you've made. Financial risks tend to deal with things like reporting requirements, fluctuations in currency or other issues. So, sort of the things that your CFO would be dealing with in his finance department typically. And then reputational risks are obviously one about public trust and market perception of your company, which again is an intangible asset, let's say, but that provides obviously a lot of value to your company. So in the IP area, really identifying risks at the highest level comes down to, in our view, knowing what IP you're trying to risk manage. So taking an inventory effectively of the internal IP that you potentially have risks or want to protect in certain ways, and IP that sits with third parties, particularly like your supply chain, who may be managing your IP or maybe managing other companies' IP in ways that could affect your own business. If your supplier is involved in counterfeiting for someone else, if they get shut down, you can have supply problems yourself, obviously. And then from the inventory of IP, we think that developing a matrix of IP risk is a very good step, and that is, taking a look at which risks you have and where those lie. Is there a risk internally at particular departments? Is there a risk with a joint venture partner? Is there a risk with your own company's operation in particular countries? Is there a risk with third parties' operations, really all up and down your supply chain?
So if we take a quick look at the different types of IP risk, as Alan mentioned, you have risk with suppliers or joint venture partners, and then you get into certain types of specific risks, cybersecurity risks, the risk of using pirated software, which opens a gateway for malware to come into your system or for hackers. Departing employees are a major risk, as well as counterfeits flowing into legitimate supply chains. And here it's been really interesting to look at. We see counterfeit components flowing into legitimate finished goods, and we also see counterfeit product flowing into legitimate distribution channels. So it happens both up and downstream. We see issues coming up with that. The other thing that isn't on this list but that has come up several times to me in the last month or two is companies saying that they send their engineers over to work with third parties, maybe overseas, and those engineers do not specifically know what the company considers a trade secret and what they don't. And while they're in a factory showing somebody something, or maybe it's over dinner or drinks in the evening, they start to share information that they shouldn't, not because they're doing something wrong, but because they don't even know what would be considered a trade secret or confidential information. Gets back to the issue of employee negligence, which is caused often by poor management systems or poor controls that are in place. And we'll talk a little bit more about the solution in a minute. But Alan, you might comment here on something that you found related to Philips.
Well, I'm just talking about the kinds of risks that different companies face. I mean, Philips does enterprise risk management company-wide on all the kinds of risks we've been talking about, across the board. But intellectual property for them is considered both a strategic risk and an operational risk in their way of analyzing and dealing with risks. So if you look on their website, they have some very interesting discussion of all the various kinds of risks that they deal with through their enterprise risk management system. But IP, particularly for them, is a strategic risk because so much of Philips' value in the technology sector, in the lighting sector, in all of the medical sectors they deal with are directly related to their bottom line and a huge corporate priority for them. So IP is considered along with other strategic risks. And then they also look at IP as an operational risk in the running of their company day to day. Things need to be in place, policies, procedures, ways of managing IP that make sure that in the day-to-day functioning of the company, things don't get lost.
Now, we've been doing some research and surveying companies looking at the issue related to IT security or information technology security versus the broader issue of IP protection. And Alan, if you'd like to talk about that, but one of the broad foundings that we found is that a lot of companies focus on IT security, but they haven't really thought about its larger role in IP protection.
That's exactly right, and I think there's sort of a perimeter mentality. Let's say, if we put the IT protections in around our companies such that hackers can't get in, I think the temptation is to think job done. Our trade secrets are safe, our other confidential information is safe. Where, as you were saying, Craig, the risks are not just from external hackers, but employee negligence, problematic employees that may be taking things out that they shouldn't be. So the whole issue of IT security is one that needs to be looked at much more holistically. We took a look at some of the SEC filings for the major Fortune 20 companies, and almost all of them identify cybersecurity as one of their material business risks that they're trying to address. And the thing is with IT, if you look at the ISO standard, for example, one of the things the ISO standard says is, that the different systems, the different procedures and policies and things you put in place with respect to IT protection really need to be guided by the objectives of what you're trying to achieve with those IT bits and pieces. And the issue is, unless your IT system is designed and implemented and managed specifically with the idea, among other things obviously, but specifically so that you are protecting your trade secrets, things may be going out the door just because the IT system isn't tuned, let's say, or isn't geared towards protecting trade secrets. It may just be there trying to protect against hackers, which of course is just part of the problem.
And in the sorry, go ahead, Alan.
And then one of the things we've put in the white paper, which we hope will be helpful for you, is a couple of checklists and inventory type things that might be helpful in starting your own looking at the IP related risks that your company may be dealing with. So we've put a couple of things in. We put in the back is the sample IP inventory, talking about what is your IP that you're trying to protect, what third-party IP might you be having to manage, trade secrets you've received from someone else that your company is under an obligation not to let out. So doing an IP inventory we recommend. as part of that, taking a look at where that IP is in your organization and up and down in your supply chain, such that you know where things need to be managed. And then we've also put in a checklist of some of the most common types of IP risks. So for all of the different kinds of major IP, so trademarks, copyrights, trade secrets, patents, and design rights, the kinds of risks that you might face as a company. So there's a checklist here that might be helpful in your putting together your own inventory and list of potential risks to IP.
So once you've identified the IP type, really the next thing is to start to integrate it into risk management. And as I mentioned briefly before, companies typically are looking at the likelihood of occurrence and the consequence of occurrence, or in many cases it's referred to as the probability and severity of the event happening. So now that you've listed the different types of IP, it's real practical stuff. Start to rate the risk. And most companies do it on a very simple high, medium, low, red, yellow, green. Whatever it is, that tends to be how companies go. And once you start to do that, it starts to paint a picture for you of where your risk is, because no company can allocate resources across the board at the same level. You have to be strategic in your allocation of resources to try to improve IP protection. And to do that, you need to know where your risk is and make decisions based on risk. That's the whole point of this, is how do you start to think about IP protection not just as a legal issue, but really as an enterprise risk management issue. And so part of that is rating the risks, and then the next step would be to start to think about due diligence of third parties to include IP protection risk. Does that third party pose a greater risk to me than another possible third party? Those are the kind of things that you start to do to integrate it into overall risk management and how the company operates. That's part of what you do to try to get it out of being a legal issue, solely a legal issue, and make it more embedded in how the company operates.
Craig, I think just to pick up on what you were saying, IP is not just an internal problem. And we've talked to a number of companies who are quite sophisticated in their dealing with IP risk as an internal matter. So do enterprise risk management, have quite detailed systems for assessing the risk along the lines we're talking about and measuring the likelihood of them happening, but had not really done anything with the supply chain. And so, if you think about recent problems like the one Target has, Target allegedly, the likely source of their hack was a heating and air conditioning vendor. So again, I think we've sort of focused on maybe the low-hanging fruit, internally at a major multinational company, and said, right, we're doing this risk management very well internally. We're ranking the risk, we're finding the risk, but it seems like the weakest link is the problem, and the weakest link may often turn out to be someone in the supply chain that maybe you hadn't even thought of. So go ahead, Craig. Sorry.
No, that's a really good point. And the other area where we see a lot of what I'll call drop-off in performance is between headquarters and regional or country offices. We've done a couple cases where headquarters, if you think about it, headquarters will be at a certain level of implementation around IP protection. And if you talk to them, they have a high degree of confidence that their regional offices and country offices would be at the same level. But when we actually go in and do an assessment at the regional or country office level, we found in one case that only 3 of the 8 regional offices even knew that they had IP protection policies. That's how low the level of implementation was. So in addition to supply chain, I think larger organizations have a huge issue to contend with how it's embedded throughout their organization on a global basis.
One of the things that the conference board also found was that 68% of companies think their trade secret risk with their supply chain is extensive. So more than 2/3, in a low, medium, high would say this is a high risk. But only 36% viewed their internal programs for dealing with this as very effective. So really this kind of assessment, really pinpointing what exactly are our risks, where are they sitting, and what's the likelihood and potential damage of this actually occurring are hugely important steps to take.
Here we had Alan. This is another one of the forms that is available in the white paper.
Yes, and again, we tried to put these together in a way that would be useful not just to big companies with lots of people and resources that deal with ERM, but also for small companies that it may be down to one person or a small team of people to have to try to manage all kinds of risk. But we think that having a risk assessment form where you not only do the things we talked before, but do an inventory of your IP, do an assessment through the checklist of what kinds of IP risks you face and where. But then here, this particular form we've put in the report talks about an analysis of what's the likelihood of this risk occurring, low, medium, high, what's the consequence if it did occur, low, medium, high, and then the specific steps that you might take to reduce or avoid, share, or accept the risk. And again, there's a lot more detail in the report about the kinds of risk responses that can be taken. We're going to talk a bit more about that in a minute. But if you look at this little chart at the bottom of the last slide, we have the kind of risk that you are dealing with. You may have a risk that's very low probability. I think Craig's Coca-Cola example, it may be a low probability risk that kind of trade secret leaks out. But if it does, it's a huge risk and one that you will want to manage in a very careful way. Similarly, the higher you go with the consequences and the higher you go with the likelihood, the more likely those are things that you want to put at the top of your list than to work on a risk management plan for that.
And then, what it all boils down to is how do you manage them? So identifying the risk is obviously an important step, but then ultimately, how do you manage it? And in the case of IP protection, you need to be thinking about the risk response and the type of monitoring and review that would take place. So here the specific actions for you to think about would be to start to assess and improve your internal systems to protect IP, but not only inside your company and in your other offices, but also you have to have systems to protect IP in your supply chain. What are the requirements that you have of third parties? What kind of monitoring do you do of third parties? These all become critical things. And then ultimately, the ability for you to assess and possibly help improve the ability of third parties to protect your IP or others' IP. And it's that piece that really is sort of the ultimate goal, is to look at your supply base or distribution base and identify the priority companies that you're working with and make sure over the next 3 or 5 years that they have systems in place to improve IP protection. This is a mutual benefit to both your company and their company. And this is the type of thing that needs to take place in the future. Again, if you think about quality management systems, that's become common practice. Is companies help their suppliers improve quality. They help their distributors improve efficiency of their distribution system because there's a shared responsibility and a shared benefit of accomplishing that. So that's where it gets to at the end, is how do you manage? And we're going to go into a little more detail in the time we have left on the pieces of an effective IP protection program, and we'll kind of break it down for you so you can actually see the 8 components of what we think are the effective pieces of IP protection.
I think this just highlights the fact that companies, the ones we've been talking with, we've had sort of more than 60 companies come through the CREATE program and do self-assessments and have independent evaluations. And in talking to these companies, looking at them from all kinds of countries all around the world, it's been really interesting to see. And we've done a report that's also on the website on our pilot program. But really, there are all kinds of areas where risk management, is taking place, but also some places where risk management needs to be improved. If you look at some of the statistics here, 80% of the ones we've been working with have few or no written procedures related to IP policies, for example, and procedures. 45% are completely reactive, for example. So what we're talking about here really, and this gets probably to the next slide, is not just being reactive, not just doing what we normally do as lawyers, and that is rely on our contract. We spend a lot of time on the contract. We do some due diligence perhaps at the beginning. We know how to litigate or go to the police if there's a big problem. But we sort of, in a lot of companies and in countries, stay reactive otherwise. We sit in our office and just hope nothing bad happens. And really marrying the management system approach to IP protection and risk management is a huge step forward for a number of reasons. One is building awareness, obviously, throughout the company. Who needs to be doing what? How do we manage this from day to day? It communicates clear expectations of everybody involved. It can be preventative as well as proactive, which is a huge leap forward. And as we've been saying, it can build on the systems that your company probably has in place for some other kinds of risk that you're facing, whether it's labor or environmental or quality control or any of those kind of things.
And I think that the thing that I want to highlight here, Alan, is the idea of shifting from being reactive to preventative and proactive. I think that really is the heart of what we encourage companies to do. And the enterprise risk management is a first step, and a very critical first step in knowing where the risk is and being able to strategically allocate resources. But conceptually, companies need to shift away from this kind of reactive approach to really becoming more preventative and proactive, especially if you start to think about what's happening with third parties that you deal with and people in those third parties. So we've been talking a bit about the idea of management systems and what a management system for IP protection looks like. So what we're going to do now is actually break it down. And in our opinion, it should have 8 component processes. So you start off and you need to have policies, procedures, and records. This really is foundational. What are the policies, which would be the rules that you want people to follow related to IP protection? But then what are the procedures? And those are the steps that you'd want people to follow in order to be able to adhere to the rules. And then finally, the records. What you need of the fact that they're following it. So if you have a need-to-know policy, only those who need to know can see certain confidential information. The procedure would need to define how that works, and then the record would simply support that only those that needed to know saw it. Without those pieces in place, it's really hard to have anything that's concrete, and certainly hard to find anything that is improvable. So as we work across, the next thing would be a cross-functional compliance team. And this is really important because in order for those procedures to be practical and in order for them to be well implemented, you have to have different departments involved to help to shape it. You can't have the legal department defining a bunch of procedures that then is given out to the salespeople or the procurement people or the sourcing people, because we know historically that people do not follow compliance procedures that don't allow them to do their job. So that's why you need the input from the different departments in the beginning. Then we talked before about risk assessment and really the importance of risk assessment over here. And we've gone over that quite a bit. But then the next category would be management of supply chain. So what are the contracts that you would have in place with third parties? What kind of due diligence is conducted of third parties? And specifically to IP protection. We talk to a lot of companies that obviously conduct due diligence on financial stability and maybe quality, maybe the ability to meet, does the company have a certain capability, maybe on health and safety, but they're really not conducting any due diligence on that third party's ability to protect intellectual property. And that's an easy addition to a process that's already taking place. Security and confidentiality management is a critical piece. This tends to be where companies are strongest around the world. The reason for that is that many manufacturers obviously have physical security to prevent theft of goods and things like that. And that's kind of evolved into electronic or IT security. There's also a lot of vendors out there pushing this, and it's increasingly important. So this tends to be where companies are strongest today. Then as we work our way down these last three categories, training and capacity building, do the employees or third parties get any kind of training on what the policies and procedures are? Monitoring and measurement. And monitoring and measurement is what we found to be weakest globally. So we found that companies were really not doing much monitoring related to IP protection, one of the weakest areas. So that gets to the idea of it being reactive. And then finally, corrective actions and improvements. What do we do if we find problems? Do we fix it at a surface level, put a Band-Aid on it, or are we actually doing some kind of root cause analysis to prevent it from happening again? And I'll tell you that once a crisis has happened, that tends to be when companies start to look below the surface. So after a huge security breach, that's when they start to look to say, well, how do we keep this from happening again? But you can be more preventative than that and more proactive, and that's what we encourage.
Craig, I think it might be worth pointing out, too, here that what we're talking about is that the kinds of risk responses that you may need to take within your company aren't limited to just one of these particular areas, but need to be looked at across these 8 areas, to be sure that you're not forgetting something. So even if you think about something like, potential IP going out the door through the IT system, so cybersecurity, IT risks, you look at these categories and it should be fairly obvious that, IT policies and procedures are really important. Having the records, the paperwork in place with your suppliers and with your employees, having more than just the IT department working on its own with respect to IT security, but also talking with legal, talking with compliance, talking with supply chain, doing risk assessment of where and how these possible IP risks might take place with the IT system, obviously dealing with supply chain. And there's all kinds of security and confidentiality management steps that could be needed in a company and with the suppliers. You think about not just the perimeter protections, but how do your employees deal with your trade secrets, for example, on their own telephones, on their own mobile phones. Mm-hmm. How do you monitor when somebody leaves the company that they're not taking your crown jewels out the door? So all of these areas are potential risk response areas as well, and we just encourage kind of this holistic, broad-based thinking about where are all the places we probably need to do something, implement some management systems in order to protect our IP or protect against IP risks in our company.
really critical point, and you actually could go through these 8 categories and very specifically focus just on trade secrets, for example, and just say, as I go through this, I'm only thinking about trade secrets right now. I'm not thinking about copyright or patents or trademark issues. So that would be one way to go through it. And ultimately on this next slide, what we get to is we evaluate companies on a scale of 1 to 5, with 5 being the most mature. It's a sort of a classic maturity matrix idea. But the thing I want to point out here is that it's really all about system development and implementation. So if we think about things, a good management system is not a bunch of paper. A good management system, my definition is trained, committed people routinely following procedures. So to get to that, you have to train them. You need commitment, which means you need senior management support. Routinely following procedures means the procedures need to be practical and simple and things that fit in within their job, that aren't burdensome or overly burdensome for them. So what we look at is, and we encourage you not to think of this as creating paper, but to think about getting to that implementation stage, both internally and with your supply chain. So we evaluate companies on a scale of 1 to 5, and that really gives you a starting point to see where you are. Because, one of the things that I say is that you can't improve what you don't measure. And too often with IP protection, companies don't really have a way to measure to see if they're doing well at it, how it fits in with their overall risk management or supply chain issues. So this is kind of the heart of what we have built, is a way to assess the maturity of what you have in those 8 categories.
Let me just kind of wrap up with the other kinds of resources that we have at create.org, and we encourage you to go to our website or get in touch with us if you're interested in looking at some of these. We do have what we call Create Leading Practices, which is really a 3-step service that follows the 8 categories that Craig was just talking about, but allows an online assessment, so one that you can do internally at your company or have your suppliers do or other business partners do, and have a ranking along the lines that we've seen. There's a possibility for expert evaluation as well, an independent evaluation, looking at those scores and those representations a little bit more objectively. And then we've got all kinds of improvement tools. We've done a 200-plus page improvement guide for intellectual property, but there are online improvement tips and other things that will not just be one-time assessment, but will allow you or your suppliers to improve over time. We've also developed, we have 3 e-learning courses that are available online. It can be done. There's an introduction to IP, which is kind of a basic one for pretty much any employee or supplier that you might be dealing with. We've done a little bit more specific one on trade secret protection, talking about the kind of risks and activities that are appropriate with respect to trade secrets. And then we've also got one on anti-corruption. Create has a whole anti-corruption side, like our IP leading practices, that are helping companies to manage the risk of bribery and other corruption. And then there's all kinds of workshops we've been doing. There's implementation guidance. There's some consulting and webinars like this one. So if you have any interest in finding out more or doing more in this area, please do take a look at our website, create.org, and you can get in touch with us at the email address info@create.org.
Well, I want to thank everybody for joining. We do have some time left for questions, and I actually saw one question coming in already. But again, our mission is to help companies improve IP protection in their supply chain. And to do that, we have a host of things to try to make it as easy as possible. It's a journey. We all admit it's a journey, but companies need to start on it, and we're here to help you with that. So the question that came in was, somebody asked about some practical examples of real specific things related to IP protection in manufacturing and what some of the issues with third parties would be. And in response to that, Actually, one of the things, I had a call just a couple weeks ago on this topic with somebody, and they said the biggest three things that they worried about was tooling and what happens to tooling after its useful life is done or when they switch products. So that's a real tangible thing. The other was design and development. During the product design and development phase and dealing with contract manufacturers during that phase, they had a lot of concerns around that issue. And then the final one was what happens to defective merchandise and overruns. So there's one practical example of a company with real challenges. It's not a trade secret issue in that way. This is, manufactured goods. But they had three very specific things, all of which really could be addressed through improved management systems to try to reduce the risk. Alan, any other comments from your side on some of the practical applications?
Just to give you another example, I talked with a company actually in the U.S. who was a supplier doing contract management, contract supply for a major, for major multinationals, and they're getting components, tooling, other things from their customers, and then manufacturing parts and other things. So we talked to them, and they're very keen to protect all of these things. But when we went through a bit of the detail of what happens when designs come in, either on paper or email from the customer. And the answer was, well, we print them out and put them on all of the machines around the factory. So, there wasn't any particular need-to-know system in place, let's say, and there wasn't any real, let's say, security that would prevent any of those from just being put in someone's pocket and walked out the door. The other kinds of things that I've talked to companies about is, in systems where everyone in a small company has access to all of the IT systems. If a manufacturer is getting confidential designs from a customer, if everyone's got access to everything, that just multiplies the risk that that's going to go out the door, either on email or on a personal device or on a memory stick. So I'd say security and confidentiality, IT security, is one that a lot of companies have with their supply chain.
So we have another question that came in about ESM systems on the market today, and do we recommend any beyond the good work that we do? I am not really familiar with the different technology solutions that are available. I do know that there's a lot that are very specialized. So I know that there's some that focus specifically on patent issues and being able to track patent utilization. I was at a licensing executive society where there were a number of vendors that were really focused on systems for patent protection and licensing. I spoke at an anti-corruption event, an anti-counterfeiting event recently, and there was a lot of technology there very specific to trademark infringement and looking at trademark infringement and the ability to identify trademark infringement on the internet or in the marketplace. Alan, do you have any insight into that? I really couldn't name any specific vendors in that space.
I think that's right, and one of the things, I've been talking to a European multinational recently, and they would very much like to do some benchmarking in this area, and they asked the same question, and that is, is there a standard for this? And I think the answer is really no as of this point. I mean, CREATE has, let's say an independent assessment and ranking that we try to do consistently. But this is really something that at the high end, normally what happens is a company would go and hire a major consulting firm or a major financial firm and have a pretty expensive thorough review and implementation here. It wouldn't be something that would be scalable to a small company in some cases, and B, it's not going to be something that will let you compare to other to other companies. So this is we're pretty much on the cutting edge, I'm thinking.
So we have another question that came in that is more on the legal side, and Alan, I'll let you take this one. In terms of protecting intellectual property, does it make sense to entrust copies of IP documentation with a neutral third party that would help them defend against or file a claim against someone else?
Well, I mean, the closest one that I have dealt with on this is the whole issue of source code escrow. I don't know if that's the kind of thing you're thinking about. But
I think that seems where the question is going with. I think in that kind of direction.
I mean, I think the thing with all of these is that you're really down to the weakest link. So if the issue is, making sure that you can, for example, check that the original protected material, the trade secret of the source code, is actually, what this person has. Having a source code escrow, for example, would help you in court to say, well, we put this out with this neutral party 3 years ago. We found this on the internet. This will show that this is the exact same thing. But when you get down to the actual enterprise risk management, where the problems tend to come, again, as Craig was saying, are internal. And that is, who's got access to your secrets? How can those possibly leak out? Who's got access to your copyrighted material, or who's producing your trademarked things? And I'd say a lot of those just, having an external third-party escrow or third-party filing place wouldn't necessarily address those risks at all.
We have a couple minutes left. Any other questions coming up? No, we don't at this point. So we want to thank you very much for joining us, and thank you, Alan. And it's been a pleasure to get a chance to talk to all of you about what we do, and we hope that we hear from you in the future, and really to help you make improvements in what you do and what the third parties that you deal with are doing related to IP protection and to reducing your risk. Thanks very much.
Thanks a lot. Bye for now.
Bye.